In California, you can't reject a renter just because they have a Section 8 voucher. Posting no Section 8 is illegal, and it can land you in a discrimination lawsuit. I'm Chrissy Wade with Wellspring Property Management, and for over the last 10 years, we've managed over hundreds of units across the state of California. So we know these laws inside and out. By the end of this video, you'll know exactly what California law requires, how to screen a voucher holder, and the legal way, how to screen a voucher holder the legal way, and how the program actually pays you. So let's get into it. A lot of landlords still think accepting Section 8 is optional. In California, it mostly isn't. So I'm going to cover three things: what the law flatly requires, what you're still allowed to do when you screen, and how the program actually works so you know what you're signing up for. All right, so step one, the law. You cannot say no. Here's the rule that changed everything. Since January 1, 2020, under a law called SB 329, your source of income is protected. It's a protected class under the California Fair Employment and Housing Act. And that law specifically defines the source of income to include housing subsidy paid to the landlord on the tenant's behalf, which means Section 8 vouchers are covered. In plain English, you cannot refuse to rent to someone just because they have a Section 8 voucher. You cannot post no Section 8 or no vouchers in your ad, and you cannot apply tougher rules to voucher holders than you would apply to everyone else. A second law, SB 222, added veterans VASH vouchers to that same protection and made military and veteran status protected too. This is enforced by California's Civil Rights Department, and a violation can mean a complaint, a lawsuit, damages, and attorney's fees. Some cities and counties had these protections even before the state did, and a few carry their own stiff penalties on top of the states. So that old "we don't participate in Section 8" line isn't just a bad policy, it's against the law. Step two, what you can still do. Now, here's what landlords get wrong in the other direction. The law does not say you have to rent to every voucher holder who applies. It says you cannot reject them for having the voucher. You can still screen. You just have to screen fairly and consistently, using the same criteria you would use for everyone else. So you can still look at rental history, landlord references, and whether the applicant can pay their share of rent. But there are two California-specific rules you have to follow. First, the income math. If you use an income to rent ratio, say you require income of 3 times the rent, you have to base that on the portion of rent the tenant actually pays, not the full rent. The voucher covers most of the rent, so requiring them to earn 3 times the entire rent defeats the whole point, and it isn't allowed. Second is credit. Under SB 267, in effect since January 2024, you can't reject a subsidized applicant based on credit history unless you first give them the option to show an alternative proof that they can pay their portion. That could be bank statements, pay records, or benefit payments. If they choose to provide it, you have to reasonably consider it instead of the credit score. You can still verify their identity, verify employment, and check landlord references. You can't just use a low credit score as an automatic no. Step 3, how the program actually works and pays you. All right, so how does Section 8 actually function once you're in? It's a federal program run by HUD that managed day-to-day by your local public housing authority, PHA. The money split is the headline benefit. The tenant generally pays about 30% of their adjusted income towards rent, and the PHA pays the rest directly to you, usually by direct deposit, every month. That government portion shows up reliably. The setup goes like this. You contact the PHA and get the landlord packet. You submit a request for tenancy approval, and along with your lease, before anyone moves in, the unit has to pass a housing inspection. That's been the housing quality standards inspection for a while, and HUD is moving everyone to a newer standard called the NSPIRE. But either way, they're checking for safety, working basics, heat, smoke, carbon monoxide alarms, no exposed wiring, no leaks, and no major hazards. The PHA also runs a rent reasonableness review. Your rent has to be in line with comparable units nearby. You can't charge a voucher holder more than you would charge anyone else. Once the unit passes and the rent checks out, you sign a HAP contract. The HAP payments contract and the PHA and the tenant signs the lease with you. One thing to know, the payment standard the PHA uses is a cap on the subsidy, not a cap on your rent, and any rent increase later goes through the PHA in another reasonableness check. Now, step 4, should you accept it? The honest take, even though it's largely required, it helps to know the real trade-offs. On the plus side, a big chunk of your rent is guaranteed and paid directly by the government, which is about as reliable as rent gets. You get a larger applicant pool, often lower vacancy, and voucher tenants frequently stay longer because the assistance is hard to move. On the other side, you've got the inspections up front and re-inspections over time. You've got PHA paperwork and timelines, and your rent is bound by that reasonableness. None of that is a deal breaker though, but you should plan for it. And to clear up a common question, you can still collect a security deposit from a Section 8 tenant. It just follows the same California rules as everybody else. 1 month's rent under the current cap and never more than you would charge a non-voucher holder. You also keep the right to evict for real cause like non-payment of the tenant's portion or a serious lease violation, following the normal California process, of course, right? 2 last things, local rules and your PHA. First, this is a statewide picture, and some cities and counties layer on their own source of income rules and penalties. So check your local ordinances. Second, the nuts and bolts, the forms, the inspections, scheduling, the payment standards all run through your local PHA. So that would be your first phone call when you're ready. That's the no BS version in California. No Section 8 isn't a choice you get to make anymore. The smart move is to screen fairly, get your unit inspection ready, and treat guaranteed subsidy as an asset it is. Before you go, here's something most California landlords actually never run the numbers on. Between the legal screening, the inspections, the PHA paperwork, and your own time, self-managing a Section 8 rental can cost more than it looks. So I built a free cost calculator that shows you what self-managing really runs you versus handing it off to a property manager. Plug in your numbers at the link below, and I'll get it over to you. Now, if you are a Wellspring Property Management client, we handle all of this for you already. If you want to contact us to discover management services, feel free to reach out to me at wellspringpm.com.